I never pleaded demur. There was
You
a
stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept
no.
as to what they mean. Let's call the case People State of Michigan versus Tariq Day.
In Michigan, Senior Assistant Prosecuting Attorney for the people.
What's your name?
Tariq Samar Tariq Ade, the executive of the Tariq Samar Tariq Ade Living Trust. Last owner, Tariq Ade, Wilson Estate.
Sir, you indicated that you wish to represent yourself on this matter.
Yes,
All right, you understand at your arraignment, you were given the charges that were filed, have been filed against you.
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeting and eluding,
Fleeing and eluding third degree.
third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
I do, but I have some questions.
As soon as I get through this, you have indicated that you wish to represent yourself. I have to advise you that there are some dangers in you representing yourself. You understand that, sir?
I do comprehend.
And you understand that if you proceed to represent yourself, that the court is not going to assist you to understand the procedures or anything regarding the court proceeding, that you will be responsible for that, and I will be holding you to the same standard that I would be holding the attorneys in the room in terms of even ruling on evidence or anything along those lines in regard to the procedure and the process. You understand that, sir?
Correct. I comprehend.
All right. You also, so I will ask you again, do you still continue to wish to represent yourself in this matter?
Yes, I will be defending myself.
You understand also, sir, that should you change your mind and could not afford to hire an attorney and wish to be represented by an attorney, the court would consider making sure that you are afforded counsel. You understand that?
I comprehend.
How do you wish to proceed on this matter, sir?
First, I want to like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party Wall Street Towing and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser. With the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest, cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Done. Finished?
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance, certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was
You weren't able to do what?
provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have more tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not this time.
All right. So how would you like to proceed next on this?
I'm entering a plea of demurrer.
Okay, you've already done that.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer. There was
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept
No.
as to what they mean.
demurrer and mute are two separate things, but that's neither here nor
No, they're not. You have no legal degree. They are not, they are not,
Don't need a-
they are not,
I'm not here
they
to-
are virtually the same thing. So where do you wish to proceed now?
As I stated, my
Do
motion,
you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs
You
to.
don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery should be
discovery?
provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery,
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes,
Do we have copies of discovery available that can be provided to this defendant?
No, Your Honor, I know that the PD was representing this individual. I don't have copies right now.
I got you. Okay. So are there copies of the police report as well as other discovery that's in the hands of the public defender's office?
I do see traffic stops and discovery videos onto our program.
All
We
right.
have documents.
All right. Those need to be gotten to the defendant. How soon can those be gotten to the defendant?
I can get those in hopefully by tomorrow around.
You have an address for him to send those to him.
Yes, I do. I can confirm it with him too.
All right. What do you have as the address? Do you have an address on, is it share?
I do, Your Honor.
Okay.
Or, well,
Okay, gotcha. All right, you'll make sure that that is sent to him.
I will.
You also have an email address so that all things can be emailed to him also.
I do, Your Honor.
All right. Very good. Sir, did you wish to then have another PCC or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threat and duress of coercion of you saying that you would help put out a bench warrant for my arrest. The subject matter in regards to the name as well as the vessel that was used is again under it was conveyed and is held and protected within the trust. And according to Article 1, Section 10, and Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly and the trust is properly functioning at this time. So with that,
All right, so here's what we'll do because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong. Because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
awesome. So that would be the next step, and I can get those in today. And
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
I'll adjourn the probable cause conference in this case. April 25th, 2024 at 3 p.m.
Is it possible to get another
It's
week for
in person.
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple councils extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable.
setting the date
So,
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PCC, to a preliminary examination.
just for the record, I put it on the record that I object, but under threat, direction, or coercion. Again,
Your objection is noted.
right, and under threat and duress and coercion, I'll be here.
Is there anything else?
I said what I need to say.
Anything else from the people?
No, Your Honor, thank you.
Bond will continue.
Am I waiting for paperwork or get it from the front?
Pardon?
Am I waiting for paperwork regarding the next?
No, you may leave.
Oh, is it being mailed, or I'm trying to figure out how do I get the paperwork?
You can check out at the front counter.
Okay, thank you. That's all right.
That it for me, Ann?
Yes, sir.
Thank you, everyone. 14A stands adjourned. Take me off, please. Calls case, People versus Von Musser.
Assistant Public Defender Quinn Anderson on behalf of Mr. Musser. Mr. Musser, state your name, please.
Vaughn Musser.
Thank you. What are we doing?
Your Honor, in this case, an offer's been extended. At this time, Mr. Musser is rejecting that offer and would ask to have this matter set for a preliminary exam and may address his bond at the appropriate time.
Discovery is complete.
It is, Your Honor.
Would the people have their witnesses available the 23rd?
We'll do our best, Your Honor.
Preliminary examination in person, April 23rd, 2024, 9 a.m. That's before Judge Washington. Yes, that's the bond.
Your Honor, as to bond and speaking with Mr. Musser, there's nothing else that's holding him in custody at this time. He did have a probation violation hearing, I believe earlier this week. He's currently scheduled to be on a GPS tether and a personal bond in that matter. He indicates to me that with regards to no contact, he would be able to abide by that. It's his understanding that the complaining witness resides in West Bloomfield with her father. Mr. Musser resides in Ann Arbor. He did have a job at American Soil Products. He's unsure at this time if that job is being held open, but he's hopeful that he will be able to return should the court allow him to be released. We'd ask for a personal bond.
Response.
Your Honor, in this case, you requested $150,000 cash security, and you were given 25,000, 10%. This is the third. The offer that was extended was for the defendant to count 2 in exchange for dismissing count 1. He does have a VOP up in 22nd Circuit Court, which he's posted bond. There are his criminal history includes a home invasion from 2006, a UTA from 2006, R&L from 2005, a DVD from 2007, as well as 2009, and a DV second, released from a DV third in 2011. The defendant is currently on bond for a IDAC and failure to stop at the scene of a personal injury crash. That is what he's up out of 22nd Circuit Court for in the BOP. This was pled down to WI causing serious impairment. The victim reports in this case that the defendant just got off of his alcohol and has already gone back to drinking. She described alcohol as being involved in this situation. Here, the defendant attempted to take the victim's phone and then struck her on top of the head. He also grabbed her arms. The defendant did these things several times. He scratched her and threw a water bottle toward her at other points. I am also concerned because while he was arraigned on April 4th, prior to that, he called the victim 4 times after being taken into custody from jail on April 2nd and April 3rd. My understanding is that these calls were made and they expressed and conversed about the fact that the victim has already reached out to the magistrate and judge to explain that the dispute has been resolved and that she wants the defendant to come home, and that she's agreeing to change her statement and not testify and wants the charges to get dropped. I'm extremely concerned. I understand that there was not a no contact order in place, but given the nature of these calls, after he'd already been taken into custody on a DV with 3 prior DVs and he was on probation at the time, I don't think a PR is appropriate. In fact, I would not think that the 25,000 with the 10% is appropriate.
Anything else?
Nothing other than to add that the bond conditions had not been in place. And in speaking with my client, and I've not had a chance to listen to the call, but it's his position that it was the complaining witness who was making the statements with regards to the case and not that he was in any way encouraging any action on her behalf. Other than that, Your Honor, we don't have anything further.
Motion for bond denied, but we'll continue.
Thank you. Let's you call before the 23rd, okay?
Court does call the cases of the People versus Daryl. Well,
Overwater Assistant Public Defender on behalf of Mr. Roberts.
your name, sir?
Daryl Stephen Roberts, sir.
Thank you. What are we doing?
Your Honor, on case 24F30419, Mr. Roberts will be waiving his right to a preliminary examination.
No, sir. Wanted to go to the one.
That's on the OWI. You're waiving on the
Oh,
OWI.
sorry, sir.
Thank you. He'll be waiving on case ending in 0419, and the matter ending in 1214 would be set for preliminary examination.
On the one being set for preliminary examination, is discovery complete?
To my knowledge,
Would people have their witnesses available on the 23rd?
We will do our best here.
On that case, that ending in 1214, preliminary examination will be set in person, April 23rd, 2024, 9 a.m. before myself. On that case, bond will continue. On the other matter, sir, you're waiving your right to a preliminary examination?
On the OWI, yes, sir.
Yes, sir. And you understand that preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
All right, yes, sir.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
On the OWI, yes, sir.
Yes, sir.
Thank you, sir.
Okay. People also waive their right on that case.
Yes, Your Honor.
Preliminary examination having been waived, defendant's bound over on a single count.
I acknowledge receipt of the information, waive its formal reading. My client would stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in that matter will be set for
May 2nd at 1:30 p.m. with Slade Thursday.
May 2nd, 2024, 1:30, Slade Thursday, you said?
Yes, sir.
Slade Thursday.
Your Honor, may I address the complaint bond, please?
Sure.
I do have information that,
On which one are you addressing, Bob?
on 24FB1214.
Okay, go ahead.
Your Honor, my understanding is that the defendant in the case has not been contacting the victim directly. However, he has been contacting the woman with whom the victim lived. And based off of those communications, it does appear that he has been, through the woman with whom the victim lives, her name is Stephanie, she has been coercing, at the defendant's instruction, the victim not to press charges, as well as not to come to court, going so far as to get the victim to make a recorded statement that that was his intention. He also, I will say, has made admissions as to the nature of this offense on the recorded line. So I am extremely concerned if his phone privileges are to stay in place, that this indirect contact with the victim will continue and affect the victim's willingness to participate if it has not already been irreparably damaged.
Would note the person to whom Mr. Roberts is allegedly speaking is daughter. The complaining witness is her husband, but there's no evidence that's being proffered at all that the daughter has had any contact with her husband regarding conversations she's allegedly had with Mr. Roberts, or that she has in any way coerced him not to come to court. And there's certainly no allegation that Mr. Roberts has done that. That being said, I have advised Mr. Roberts regarding his phone calls and what he should be talking about and what he should not.
Just so that I'm clear, the individual Stephanie are there indications that is it the father talking to the daughter about whatever, or are there indications that Stephanie's supposed to do something with that information?
On April 1st at 21:46, the defendant asked Stephanie, "What is Nate saying?" Stephanie says, he says he will do what he can to try and get you out. The defendant then says, he understands he brought this on, right? Stephanie said, yes. Defendant says, you gotta tell him he has to drop the charges. There will be no bail. Stephanie says, he never pressed any. The state picked it up.
given that defendant's phone privileges at this time are ordered revoked.
Thank you, Your Honor.
Court calls case People versus Santana Taylor. All three cases.
Prosecuting attorney Morgan Burrows on behalf of the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Santana, who stands to my right. Mr. Santana, can you please state your name for the record?
Santana Taylor. Taylor. Okay. Yeah, go ahead.
Your Honor, I would be asking for a week adjournment. I was not able to fully read the discovery with my client.
No, I don't, just,
Are we?
I don't want to adjourn.
Hold on a second. You weren't able to go through everything with your client on all, because she's got 3 cases.
Yes, and two of which I didn't have all of the, I didn't know if I had all this or not because we didn't finish review, Your Honor.
All right.
Well, I've been through we've been through all of them with the first one and the last one. I don't want to
What do you
adjourn
mean
and I
you've
want to
been
go to
through
a
all
preliminary
of them?
exam. I don't want to adjourn. I want to go to a preliminary exam. And I went over all this with the last person, and we went over it at the county jail yesterday.
What last person?
The person I had before it got adjourned, the last adjournment. I just want to go to a preliminary exam.
No, I understand that.
And I went over all my cases.
So I guess all I'm trying to find out, I hear what you're saying. Was all the discovery there the last time or not, counsel?
Your Honor, I've only been on this case a couple of times. In checking with the note in the notes, it was unclear to me as to whether or not the latest reports were reviewed in their entirety. I just checked with Prosecutor Barroso. She advises that there is no further discovery to submit. So if the court is comfortable, I would just I will mail over the police reports to my client, and if he's ready to set, then I'm happy to set.
I've been through. I just want to go to my preliminary.
I know. I heard you the first time. We'll have the witnesses available on the 23rd.
We'll do our best, Your Honor.
Preliminary examination in these matters will be in person, April 23rd,
Thank you.
2024, 9 a.m. before Judge Washington. Court calls the case People versus Sheldon Brumett.
And good afternoon, Your Honor. Joseph Hall, appearing for and on behalf of Mr. Brumett, who appears via Zoom. And we appreciate the court's short notice allowing us to appear via Zoom, given Mr. Vincent and my circumstances.
Okay. We do not have Mr. Brumett.
We have, I see the firm is down there. We could unmute and turn the camera up. Well, Your Honor, I just got, let's see. Your Honor, I just got word that he is walking in from the waiting area outside. Yep. Up, here we go. We have a change of name.
You can appreciate this last minute request, yeah, but this isn't going well.
Well, you know what, Judge, since I've had no working knees, not much has, I promise you.
Yes, how are you doing, sir?
I'm much better, Judge. We're hoping that May 2nd I'll be allowed to get behind the wheel again and grace your court with my in-person appearance.
Oh, joy. Okay.
So, Your Honor, I mean, I'm told
Oh,
he's
there he is, I think.
all right. We've got an unmute. Oh, now we got mute again.
No, unmute. Mr. Brumett,
This would be,
you changed the name.
Yeah.
there we go.
There might be.
There, we've got Mr. Brumett. Mr. Brumett, if you could state your name for the record, please.
Sheldon Brumett.
Thank you very much.
Thank you.
Once again, Your Honor, I appreciate Your Honor and the court's staff accommodating our request. We would request an adjournment in this matter to obtain additional discovery. And I believe this has been discussed with all parties through Mr. Vincent.
All right. You said you might be back behind the wheel May 2nd?
That's correct, Judge.
Okay, we'll put it out to that date. Let's see if you can drive in here. We'll have a bunch of police officers out there, so stay within the lines. May 2nd, 2024, 9 a.m. or as your invite indicates. Bond will continue. Thank you, Mr. Vermette.
Thank you very much, Your Honor. Thank you to all involved.
How's the case? People versus El Haji, is it Dambuya?
I guess it's close enough, Your Honor.
Okay, well, I did what I could.
Good morning, David I. Goldstein, appearing on behalf of the defendant.
Your name, sir? Okay, you can take hands out of your pockets first. Thank you. All right, what are we doing on this case?
Your Honor, I just received the video, which is a very critical part of this discovery yesterday, so I have not had an opportunity to review it with my clients, so we're asking for a 2-week adjournment.
2 weeks. Probable cause conference, April 25th, 2024, 9 a.m. Bond continue.
No, I got about 4 more, so. We're calling to come see them.
Again. Recalls the case, people versus Chop. Oh, sorry.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief, appearing with and on behalf of Chuck.
All right.
Had a chance to talk. I believe we are ready to go forward with the plea.
All right. Ms. Chop, on the date and time in question, what do you do on that date that makes you think that you're guilty of this offense, of these offenses?
I busted a window.
You busted the window? All right. I'm going to ask you this because of what you said, because I have to know. You intentionally busted the window or did it in a fashion where you knew the window would break?
Yes.
All right. And did you enter the premises at that point? Pardon?
My hands were bloody, so I had to leave, go to the hospital.
And I believe in this circumstance, when she busted.
Her hand went through, it broke the plane of the property.
That's
All
enough
right.
for the injury.
Is that correct, ma'am? And you don't have any ownership interest in that property?
No.
All right. And did not have the permission of the owner to enter that property or to in any way alter that property by breaking the window? All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
Your Honor, the defense is satisfied.
The people are satisfied, thank you.
Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
6 to 10 a.m. before Judge Barr.
June 6, 2024, 10 a.m. Judge Barr. Bond will continue. Court does call the case, People versus Christopher Small. Well, now I can hear.
Good morning, Your Honor. Amy Bass on behalf of the.
Good morning, Your Honor. Please, this honorable court, David Burgess on behalf of Christopher Small.
Your name, sir?
Christopher Small.
All right. What are we doing?
Your Honor, I've spoken to my client regarding his right to an exam in this matter. He's voluntarily waiving his exam and having his case found over to circuit court for further proceedings.
Is that correct, sir?
Yes, it is.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed. And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution of this matter.
I do, yes.
All right. People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all 6 counts.
The court has a copy of the information.
I will get that to you momentarily. Thank you.
And as the
Counsel.
information, Your Honor, we'd waive any formal reading and stand mute as to the charges.
Defendant having waived former reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
April 24th at 1:30 before Judge Conlon.
April 24th, 2024, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you. Bond continued in this matter. Court calls case, People versus Douglas Carlson.
Good morning, Your Honor. Uwe Daus appearing on behalf of Douglas Carlson, who is joining us via Zoom.
Sir, if you could unmute and state your name, please.
My name is Douglas Carlson.
What are we doing on this case?
This case was improperly charged with felony. It should have been charged as a retail fraud second, which is a 1-year misdemeanor. So at this time, the court is in agreement. I would add count to a retail fraud second degree. The PAD code is 750.356D is in David. Misdemeanor. And I would add that count to dismiss count one and ask this court to remand to the 15th District Court for a pretrial.
You waive any further formal reading of that charge?
We do, yes.
All right.
Thank you.
And your client stands mute to that charge?
Yes, he does.
All right. Defendant standing mute to that charge, court will enter a plea of not guilty to that offense. Count one is dismissed. I'll set a pretrial on count two for
April 17th at 2:30 before Judge Salvo.
April 17th, 2024. What time is that?
2:30.
2:30 before Judge Valvo. Bond will continue. Thank you.
Thank you.
Let's call the case of the people versus Zachary Kratz.
Good morning, Your Honor. Amy Rides on behalf of the people.
Other side. Flip.
Good morning, I'm Uwe Daus, appearing with and on behalf of Zachary Kratz here for the first probable cause conference after the arraignment just not 2 weeks ago.
Pardon?
We're here for the first probable cause conference after
Okay.
an arraignment.
All right, what are we doing?
Looking for an adjournment of the PCC. Both discovery and discussions with Ms. Reiser have just started and are ongoing. If it could go just 2 weeks to the 25th.
No objection to the.
If
You gave it.
I haven't given it. Probable cause conference will be April 25th, 2024, 9 a.m. Anything further on this?
Not at present, no.
All right, we'll continue. Thank you. Court calls case People versus Dorian Ford.
Your Honor, Marcia Crater on behalf of Mr. Ford. Mr. was approaching. Mr. Ford, can you please state your name?
Dorian Ford.
Your Honor, we would be requesting a preliminary exam.
Discovery complete.
Yes, Your Honor.
People have their witnesses available the 23rd. Preliminary examination in person, April 23rd, 2024, 9 a.m. That is before Judge. Before me.
Thank you, Your Honor.
Bond will continue. Court calls the case People versus William Pattison. Yes, I know.
Senior Assistant Prosecuting Attorney for the People.
Good morning, for the record, I'm Brian Montoya, with and on behalf of William Pattison, who is standing at the podium with me.
Very good. I've signed the substitution. All right, what are we doing?
Thank you. Daytime separate preliminary cause conference. I was just retained last night. Need some time to work through the discovery and meet with my client. I'm asking for a 3-week adjournment. Your Honor. Second.
May 2nd. Would that work for you?
Yes.
All right. That objection, probable cause conference, May 2nd, 2024, 9 a.m. Bond continued.
Is that 9 a.m., Your Honor?
Well, I said everything at 9 a.m. You can be here at 9 a.m. We're always a pleasure seeing you. You can always check with us and figure out which block you're into.
I do appreciate you.
All right. Court calls case People versus Michael Rohane.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Rohan. Mr. Rohan, will you please state your name for the record?
Michael Rohan.
Your Honor, this is a waiver of the case ending in 5715, and we'd ask that the other matter set for a preliminary examination.
Got it. Okay, as to the preliminary examination case, discovery is complete on that case.
Yes, Your Honor.
And this is on case 1466. So people, would they have your witnesses available the 23rd?
Troy.
All right. Preliminary examination in that matter will be set April 23rd, 2024, 9 a.m. That's before Judge Washington. Bond will continue in that matter. And in the other matter, sir, you're waiving your right to have a preliminary examination in the larceny $1,000 to $20,000 case. Is that correct?
Yes.
All right. You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you won't have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on the single count.
Your Honor, defense would acknowledge receipt of the information, waive its formal reading, and stand mute at this time.
And then having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 30th at 1:30 p.m. with Judge Cummings.
April 30th, 2024, 1:30. Bond will continue.
Thank you.
Court calls the case People versus Michael Fitzgerald.
Attorney Feaster, Assistant Public Defender on behalf of Mr. Fitzgerald, to stand to my right at the podium. Please state your name for the record.
Michael Fitzgerald.
Thank you, Judge. I've spoken to Mr. Childers and to Mr. Fitzgerald briefly. My understanding is we want to set this matter for a preliminary examination if possible.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 23rd.
Yes, sir.
Preliminary examination, April 23rd, 2024, in person, 9 a.m. That's before me, correct? Bond will continue. Thank you.
Judge.
Bit more sincerity in that. Court calls the case to the people versus Julius Clay.
Morning. For the record, Your Honor, Erica Julian, appearing on behalf of Mr. Clay. Can you state your name for the court?
Julius Clay. Thank you.
Thank you, Your Honor. So late yesterday, I did receive an FBI report or reports from the people. However, they do not contain the actual attachments with the data that I need to analyze. It's just the body of the report without any of the attachments. And we do need to review those reports in their entirety. So we're asking for an adjournment. I was just adjourned to May 2nd, if that date is still available.
I don't remember. May 2nd, 2024, 9 a.m. Bond continued.